Administrator Van Winkle. I am Patrick Priest, the Management Co-Chair of the Management and Labor Advisory Committee meeting, and this is our June 2022 meeting of MLAC. I want to welcome everyone and thank you for your patience. We are starting a few minutes late due to technical difficulties, and I want to thank Teresa for her extraordinary efforts to run around and get it all figured out, and so thank you very, very much for that.
And I must extend a hat tip to Andrew and to Caitlin and Jeff. It takes a village.
Okay, and thank everyone online. It seems there's a lot of patience, and we've got 38, almost 40 people ready to participate virtually, and several in the room, including Sarah Duckwalt, who I have not met in person. So I'm excited to meet her in person and talk this together. So I guess with that, we will start with our agenda. Mm-hmm. And did you have any introductory things, Teresa, that you wanted to?
I do not. Thanks to the lag time before we started, I did indicate from the meeting. I will put on the record who is here in attendance, virtually and in person, because we do have quorum. So from the labor side, we have Matt and Marcy and Scott and Margaret all participating via Zoom, and then for management, Tammy is here and via Zoom, and Sarah and Patrick are here in the meeting room. So we do have quorum.
Okay, thank you very much, Administrator.
And Andrew, of course.
Great. Well, we'll go ahead and get started with the business. And the first thing on the agenda is to review and approve minutes from the May 19 meeting, which have been distributed and posted. And so I would entertain a motion, if anybody would like to make one, to approve those minutes.
So moved.
Okay, do I have a second? It has to be somebody virtually. Got to take a chance.
I'll second that. Second, Margaret.
Okay, thank you, Margaret. We have a first by Sarah and a second by Margaret. Is there any discussion before we take a vote?
I do have one item is to reflect in the minutes. Tammy was not at the last meeting, and she had mentioned that she would like to abstain from voting today because since she was not in attendance.
Okay, and we still have a quorum without
that? Actually, no. No, we do not. So with that, so what we can do is we can carry it over to the July meeting, and this actually might be a potential item for the co-chairs to discuss an additional and an amendment to our current bylaws, which is how to handle.
Okay.
The votes on minutes.
All right.
In regards to
attendance. If you don't see any difficulties, I don't see any problem carrying it forward to them.
Okay.
Okay. Thank you for that, and thank you for commenting on that. Tammy will address it. All right. So moving on from that, we have department updates, and the first item is a request by the members of the caucus to have a regular Workers' Compensation Board case law update. And it's unfortunate that due to scheduling, we're not able to have one this time, but it will be at each meeting starting in July.
That is correct, yes. And to give you a preview for what they will present at the July meeting, so the board does provide information on case law, orders and items that they've deliberated to MLAC members quarterly, so they will mention that. They will also be doing an overview of, let me look here, for the Johnson versus Safe and the Robinette versus Safe cases, in which I know we have the question that was asked by a member in regards to the Johnson versus Safe. They will make sure to incorporate that into their presentation. But I want to mention that for July's presentation and future presentations, if you do have questions in regards to cases that have been in front of the board or in the Court of Appeals or Supreme Court that you have specific questions on, you can forward those to me, and I will make sure that the board receives it and incorporates it into their monthly presentation to the committee.
Yeah, I thank you for your responsiveness to that, and I look forward to the report in July.
Okay.
All right. Any other comments on that at all from any other caucus members? All right. Hearing none, we will move on to the next department update, which is the WCD rulemaking update, and that is Teresa.
Okay. That's actually some partially coincides with the board update on this. So there was a hearing that took place earlier today via hybrid meeting. What it focuses on is attorney fees under OAR Chapter 436. The public comment period ends on June 22nd. The rulemaking is needed to adopt a rule regarding attorney fees under ORS 656.33 subsection 1, in which the Court of Appeals via the Dancing Bear versus Safe decision has held apply after temporary disability compensation benefits are obtained at reconsideration on that. And then and I will put that information, a link to the rules and such into the chats, and it's available in the room as well on that. But again, the rules have not been filed. Today was the hearing on the proposed rule on that. There were two recently filed rules, WCD 4-2022. This is the rule that replaces gender-specific pronouns. It was approved and filed with the Secretary of State's office on June 13th. The effective date is July 1st. Also, a temporary rule was filed, WCD 3-2022. This is a temporary rule that brings the disability rating standards into alignment with the Oregon Supreme Court's decision on Johnson versus Safe.
Thank you for those updates. Any questions for Teresa on those updates? All right, I'm seeing none. It was a thorough report. Thank you very much.
You're welcome.
Okay, and the next item on the agenda, I know, is something that we also requested be added to the agenda, so I know we're all eager to hear a status report on WCD Simplifying Communications with Workers project. And in person, we have Sally Cohen to give us an update.
And where would you like me for this? This hill?
And Sally, I believe the microphone is up and turned. Thank you.
Alrighty. Good afternoon, everybody. Thank you. Sally Cohen, Administrator of the Workers' Compensation Division. Thanks for asking me to be here with you all this afternoon. Appreciate that opportunity. As Co-Chair Bruce mentioned, I'm going to provide a status report on our Streamlining Communications Process Improvement Project, which is something that's falling under the umbrella of our modernization program. I would like to just share a little bit of context about where this project is even coming from. Why are we focusing on this? In 2020, as part of our planning effort for a larger business process and systems modernization effort, the division engaged a professional services contractor to provide us with a systems architecture and a roadmap for a phased modernization program. As part of that engagement, our contracted vendor met with a number of internal staff and also a number of external stakeholders to get feedback on our existing processes and programs and systems. The contractor recommended a series of interim process improvement projects that the division could work on in the interim with our existing resources to address pain points while we continue to plan for a larger scale modernization and system replacement effort. One of the interim process improvement projects that our contractor recommended was to simplify communications to injured workers and to employers. So as we are all aware, the Oregon workers' compensation system is complex, and workers and employers are inundated with communication from all different sources. So the effort to streamline communications is significant. This is a large body of work. This project is the initial step in a larger multi-phased program. For our initial planning of where to start, we identified 44 instances of required language in the administrative rules, 7 forms, and 5 publications that we want to work on first. So our project team includes division team members, as well as representatives from the Ombuds Office for Oregon Workers, the Small Business Ombuds, and the Workers' Compensation Board. We held a stakeholder meeting in March this year to solicit feedback about pain points and challenges in order to help focus our efforts. And some of the MLAC members participated in that meeting, so we thank you very much for engaging with us on that. We heard a wide variety of feedback that was provided at that meeting. Really ran the gamut. Some of the key takeaways that we heard from stakeholders included that there needs to be more flexibility with required formats, to provide workers with more pertinent and useful information. We're just not talking about streamlining, providing less information, but actually pertinent information. Also, that required language paragraphs are too restrictive. Claims processors want more flexibility to be able to provide workers with information about what they need to know, what they need to do, and when they need to do it. If prescribed and prescriptive language is required, then it needs to be in plain, understandable terms. And this was a term someone used, not sound like canned language. I thought that was very descriptive. To the issue of making it clear to workers when there are deadlines, we heard suggestions that deadline dates for appeals should be added to key notices, such as the notice of denial and the notice of closure were specifically identified. We heard that there is confusion with information for workers about what is allowed for medical providers and treatment through managed care organizations. We heard suggestions to add QR codes to allow easier access to information. One example that was given was specific to the notice of compliance poster that employers are required to post since so many employees are working remotely today. We also heard concerns that specific time frames in the administrative rules for action in notices, particularly 5-day time frames, are not long enough, in fact are unrealistic today with mail delays. We also heard that surgery approval and pre-authorization processes are confusing, and that return to work notices are not applicable to all workers, and the preferred worker program form is also confusing. It's definitely a situation where one size does not fit all there. Claims adjusters shared with us that they repeatedly get similar questions about the notice of closure in particular. If the worker disagrees, they don't know what to do next. There's no clear language about how to appeal. And we also heard other feedback that employers are directing workers to specific medical providers, that information about a worker's right to choose a provider is not clear enough on the Form 827. So it's just kind of an overview of some of the themes that we heard. We did receive a lot of input. We had a very good broad representation of claims processors, labor representatives, and medical providers at our meeting. So what have we been doing since April? Our project team has been working closely with our policy analysts and our policy unit to help assess the impact and complexity of possible changes. Again, we're initially focusing on instances of required language or notices to workers in the administrative rules, as well as some specific forms of publications. So our policy analysts are analyzing current rule language to help prioritize the work. They are identifying, for example, things like what triggers a notice or a document to be sent, whether language or content of that notice or document is specifically prescribed by statute, how many workers would be impacted, whether there is a specific time frame for response or action. Our project team is developing a weighted matrix to identify instances of highest priorities for us to work on first in a phase 1. The highest priorities will be those things that have a positive impact to workers with a low rating on how complex a change would be to implement it. So, for example, a low complexity item would be something where there is no statutory requirement that might have to be changed. We plan to categorize proposed changes and identify those things that can be worked on in future phases, those things that are higher complexity to implement. Our project team is evaluating identified instances for the necessity of prescribed notice language, including the need for prescriptive language versus flexibility to use custom language, as long as it includes specific elements that should need to be included. They are also looking for opportunities to reformat or reword notice language for readability, to highlight the most relevant information, and of course focusing on plain language and readability of content. Our project team is also developing a communication plan so we can provide regular ongoing updates regarding progress, but more importantly to get additional input and feedback from stakeholders on proposed changes as they are identified. So we look forward to sharing more information about this with you as we progress, and I'm happy to address any questions the committee may have.
Well, thank you for that thorough report. Any questions in particular? Sarah?
I have one. Thank you, Sally. I appreciate the update. And I like the concept of using a matrix to determine low-hanging fruit and where to move forward. And I've heard phase one. How many phases? Question. And what's the timeline to start implementing?
So I think the number of phases will depend on how the weighting comes out on the complexity level. If we are able to easily group things into smaller number of phases, we'll do that like 1, 2, or 3. But it's going to depend on what that looks like. Implementation is going to be depending on how complex it will be. Those things that will require administrative rulemaking changes, we will put into our rulemaking calendar that we keep going at all times. We want to be respectful of our regulated industry on how many administrative rules we have open at the same time, and how many changes will be requiring folks to implement at once. So I think it's going to depend on what that initial body of work looks like and how many rules will need to be updated.
What about the ones where no rules are coming
No
into play?
rules, we can immediately work on. If there are things where forms need to be changed, publications need to be changed, our staff can immediately start working on those things.
So
But we will want to be able to test out proposed changes with the industry folks before we just start ruling out major changes, of course.
just ballpark end of summer, like end of year, when should we start seeing some of the changes?
I think you should see proposed changes by the end of the year.
All right, in the virtual world, does there anyone have any comments or questions? See a nodding head, a couple of nodding heads, so none. Maybe I would ask, Sally, it's a lot of work, it's a long report, and Sarah, it's a tight deadline by the end of the year. It's already halfway through the year almost. Do you feel like the staffing levels that you have are adequate? Do you feel like there'll be any challenges in terms of having the people to implement and I guess even decide what you're going to start with is where you're at right now?
Yeah, I think we are well staffed with the project team and with our policy unit to be able to identify what needs to be changed. We will have challenges with anytime you slice off large things that need to be communicated out, we will have challenges with the communication of how things are to be implemented, timelines that we expect industry to start making changes and using new forms, for example, and that kinds of things. I think we are staffed in order to do that. We need to be very thoughtful about how we communicate out and the timelines we're going to require the regulated industry to follow the timelines. But yes, I think we're well staffed for this.
Well, thank you. I don't see any other hands raised, but there is in the chat one question that's not from a committee member.
I'm working on that right now, so I will post that. Yes.
Okay, so just for those that maybe haven't read the chat, it's a non-caucus member has asked, are meeting minutes or copy of report for the last modernization meeting available online?
So the answer right now is, so once the minutes are adopted, they will be posted on the website. And then so for the modernization report, the presentation was given, there was no written exhibits that were given. But I will send a direct message if there's any specific questions, and I will coordinate with WCD on providing a response.
Okay. Well, if there are no other questions, comments, or concerns, I guess we'll be getting other reports as time goes on.
You'll get additional reports.
Okay. All right, thank you very much.
Thank you.
All right, so moving on to the next item on the agenda. This is continuation of a legislative item that was approved at the last legislative session. We wanted to look at worker continuation of care, and there is a stakeholder presentation of the issue, and then it will be followed by committee discussion, and we have a guest speaker, Elaine Schooler from SAFE. She is moving
Oh,
to
and
the front.
special guest.
And a guest. Plus one.
Safe also.
And joined by Dan
And guest star Dan
Schmeling
Schmeling.
From SAFE. So it's a tag team effort. They brought their 18 here. And I will turn it over to them as we get them on camera.
Okay, hi, committee members. I'm Elaine Schooler. I'm an attorney for Safe Corporation. And Dan and I are bringing back for you an issue that was discussed throughout the negotiations for House Bill 4138, which you may recall was a time loss bill in part that also dealt with overpayments and medically stationary dates. And House Bill 4138 was a culmination of a multi-year discussion between stakeholders, including SAFE and the Oregon Trial Lawyers Association. And one of the proposals that was discussed throughout those discussions was open-ended time loss releases and the continuation of care between workers and their medical providers. And that issue, while it was discussed throughout the negotiations, was put on the back burner so that further discussions could continue here before MLAC and engage other stakeholders who may have additional thoughts or ideas on how to address this solution. So currently, in the statute, there are no limitations for an attending physician with regards to seeing injured workers, addressing work restrictions. And our proposal sought to create a system where workers and providers had a clear expectation so that care was continued, there weren't gaps in treatment, and workers ultimately weren't falling through the cracks when they needed timely and appropriate care. And would also allow timely and appropriate work restrictions to be developed and then communicated to employers. So what we're bringing forward to you today is that concept. What we're seeking is a subcommittee that could address this in further detail. Some stakeholders who were involved in this discussion included outreach to the Medical Advisory Committee. That's comprised of physicians who operate within the workers' compensation system. Many of those providers were surprised that there was in fact no standard in place for continuity of care and addressing work restrictions, and many endorsed that a standard should be in place. We feel this is an important issue, one that could be addressed through a subcommittee. It may also involve other stakeholder feedback, in particular from the managed care organizations, potentially medical advisory committee or others who have a vested interest in this. And Dan's here as well to provide an example of that would be helpful for the committee members to see how this plays out in some of our claims and can impact not only workers but also the providers and their care that they're receiving, or in some cases not receiving, but still need. Would that be helpful?
Yeah, I think that would be very helpful.
Okay.
We can pause there if people wanted to talk to Elaine first, but I'm okay with moving right into the example.
Okay, so here's an example to kind of illustrate what the problem is, or what we encounter. Think back to the start of the legislative session in early February. A skilled orchard worker was injured. They were climbing down off of a ladder, they were moving the ladder, and they pinched 3 of their fingers. So that happened on February 2nd. They let their employer know right away, so they reported the incident. And it was a short-term job, so the person was going to be employed for another week or 2 and then presumably be laid off and move on to other employment. So they finished out their employment with that employer, and then on February 10th, so about a week later, they decided to seek medical treatment. They let their employer know and a claim was filed. They sought treatment with urgent care. They were diagnosed with a contusion of their first, second, third finger, and they were taken off of work indefinitely to follow up with occupational medicine. So that's great. We found out about the claim. We reached out to the worker. We inquired about follow-up care with occupational medicine, and we were told that the worker was relocating to Southern California, and they would follow up with a provider after they relocated. So on March 4th, we contacted the worker again to follow up about care. They had moved to Southern California. They hadn't found a medical provider yet. They asked about time loss benefits, and we said, yes, you're still authorized. We're still going to pay time loss benefits. So we get the medical reports in from urgent care. It's obvious that the person injured themselves at work. There was objective findings. We accepted the claim in early March, and again, we followed up with the worker to find out whether or not they've established care with a new medical provider yet. They had not. And we let them know it had been about 4 weeks since their last treatment, and that there, was kind of an expectation that they treat regularly. And if they weren't going to treat regularly, we may move to look at an administrative closure process. And they said, okay, they'd be following up with an attending physician. So then on April 5th, we followed up with the worker again. They still hadn't made contact with an attending physician. They had the name of a chiropractor they might treat with, but they hadn't reached out yet to schedule an appointment. We followed up the next week. Do you have an appointment yet? No, they were too busy, getting settled into their new job. They had to travel back to Oregon to wrap up some things. They traveled back to Southern California, and they were hoping to find a new attending physician soon. We're still paying time loss because it's an open-ended time loss authorization. So then on April 21st, 10 weeks after the original injury, we finally send out what we colloquially call a bug letter. Basically a letter saying you haven't treated in 30 days. If you're not going to treat, we're going to close your claim. Please let us know what's going on. So the worker immediately called, said that they were trying to find a medical provider, but that they were having problems because they didn't know what their claim number was. So we gave them their claim number again, let them know, hey, we can help you if need be, but you really need to find an attending physician. So then we finally got a call on it's May 12th from a medical provider in Southern California, letting us know that this worker had reached out to schedule an appointment, but they wouldn't schedule anything without knowing what the claim number was, what the status of the claim was, and medical reports. So we sent all of that down. We spent the next 2 to 3 weeks working with that medical provider to get what they needed to schedule the appointment. So finally on May 25th, the worker was seen by a physician in Southern California. So this is roughly 15 weeks after their urgent care clinic visit in early February that they finally sought follow-up treatment. It took us about 3 weeks to get those medical reports from the medical provider. And what we got was a referral to PT for evaluation, no no work restrictions, no time loss authorization, just an evaluation of the fingers. So we followed up with that physician to find out, okay, what's going on? Is there work restrictions here? Is the person released to work? And on April 15th, we heard back from the medical provider's office that, yeah, indeed, they had released the person to modified work. They were expecting to see them back on June 6th for a follow-up appointment, but they no-showed on that. So then we asked about, okay, do you know if they followed up with a physical therapist for the evaluation that you recommended? No. No one's reached out to our office for medical records for that physical therapy evaluation. So the last I checked on the claim was just this past week. We're 18 weeks into the claim. The worker sought treatment twice. We still have an open-ended time loss authorization. We're still paying time loss benefits. We've reached out to the urgent care provider that the worker originally saw and asked them, had the person continued to treat with you, would you continue to authorize time loss benefits today? And their response was essentially, well, we haven't seen the worker, we don't know. We anticipated the worker probably would have been back to work within 4 weeks, but we can't comment because we haven't seen the worker. So this is just kind of that example of a situation where there's really no incentive, or doesn't appear to be an incentive, to seek medical treatment because the time loss authorization is open-ended. The worker's receiving a time loss check every 2 weeks. We're, 4.5 months post-injury? We can't even get a hold of the worker at this point. We followed up to ask, do you have another appointment scheduled? The attending physician in Southern California has been calling to schedule a follow-up appointment. And still to this date, no follow-up appointment scheduled. So that's just kind of an example that we see on a relatively regular basis of the problems that we have in, getting the worker into care so that they're actively, seeking treatment and recovering from their injury.
And something that's important in this one too, this claim, it was accepted for contusions, which are like bruises, but there was concern that there may be a tendon injury involved. And so for this individual, it could be really important for them to get into the provider, to get seen, to get the physical therapy. And when that communication and that consistency of treatment isn't there, then we run into the situation where it's hard to know, has the worker truly recovered from their injury? Are there other complicating factors that are impeding their ability to be seen that perhaps they can assist with, if it's transportation or locating a provider that's closer to where they live? There are resources available, but when that communication isn't occurring and that point of contact with their provider, it can lead to adverse outcomes.
That was helpful for me to know an example.
Very helpful.
All right. Well, I will just pause to see if there are questions on what was just presented at all.
I have a question, just
Yes.
on procedurally, in this particular instance, where do you go, what do you do? How long does open-ended time loss really become open-ended? When can you close the claim?
So there are different sort of tools in the toolbox. Dan touched on some of them already, where you can reach out to a provider and ask them if they can still verify a worker's ability to work. And sometimes providers will give a response that addresses the worker's ability to work. At other times, providers say, I just don't know. I can't make that determination without seeing the worker, or at least contacting, having some sort of communication with the worker. So that tool is available, but it's not always an effective way to make sure workers are staying connected with their provider and their care. And then the administrative
I
closure is
mentioned
another mechanism.
the administrative closure process, where we send out the bug letter that says you haven't sought medical treatment in 30 days. If we don't hear from you within 14 days, we're going to proceed to administratively close your claim. But if we do hear from the worker with,
Which you
I have
did.
an appointment scheduled, or I'm trying to find an appointment, if we close the claim and the worker requests recon and it basically is appealed and goes to the appellate review unit, that closure is going to be rescinded. And so there's no benefit there, because as Elaine pointed out, if the worker really needs treatment, that should be the focus. The person needs to get in, get that care so they are recovered, so that they make sure that they get the benefits that they're entitled to.
So would you just work through the administrative close process again if you continually don't hear from the
And
worker?
again,
Okay.
and again. But if they respond with, I'm trying to schedule an appointment, or I've scheduled an appointment, at that point, we should not close, an insurer should not close the claim, because the worker has responded in the affirmative that they're not recovered, that they intend to continue to treat.
So just responding and not seeking treatment is enough to keep the claim open?
Yes.
Thank you.
All right, thank you. Any other questions virtually? Okay, I don't see any, but there is this was the presentation of a problem. I would guess it would be a nice discussion item among the caucus to see if there's consensus that this is a problem. I don't know, does anybody have any comment that they disagree and thinks this is not a problem?
No, Tammy Ballard, I agree that this is a problem. I don't know if it's something that we need a work group on, or we need to come up with a good solution, but it is a problem. I do agree with that we should be addressing.
Yeah, I think that's the second part of the question. I was going to take them separate. I don't know. Does anybody disagree? I mean, I hear from the management side that spoke up, and they say there's a problem. I haven't heard from anybody on the labor side. Is there anyone that maybe disagrees with that, or is there consensus?
This is Matt Calgate. I think I would want to see it quantified in a more comprehensive fashion. I'm really seeing how big of a problem it is. If it's a one-off, like hearing that it's obviously a pretty extreme case, is that this is an outlier. I know from my experience, I'm a registered nurse, and I was just working yesterday. The amount of care that is being deferred because you can't get into a physical therapist or a specialist is pretty profound. So I'd also want to, I don't think I have a big enough picture to see, is this a systemic failure of our healthcare system, which from my vantage point is occurring right now for people who need care? And so how do we make sure we're taking a look at how difficult it is to navigate the healthcare system, and then how big of a problem is it when we're looking at all of the injured workers who are going through the system, which, you know, the system is incredibly burdensome. So how, looking at all of the workers going through, how big of a problem is it?
That's a good point. What would be some evidence that would be compelling to you to help you decide? I don't know. I'm not sure what that would
Well,
be.
I guess, you know, it seems like if you had a case like this, you have these timelines being well documented, but, you know, starting in February 2nd and having some, you know, clear points and seeing these pretty, what are apparently long times where it takes a month to get into, say, a physical therapist or to actually have a appointment arranged. So I guess you would think this would be tracked somehow, that you have these ones where we're looking at from February to June. There's only been, you know, 2 visits with an attending. There's some pretty extenuating circumstances, travel and whatnot, and no follow-up with a specialist. Is there any documentation of, like, where there's averages of amount of time that people tend to go through these processes, you know? So if you took your population and you said, okay, we know that 1/3 move very, very, you know, the fastest third move through the system this way, and then we have the middle third that are seen by their attendings and specialists and whatnot in this time frame, and then we have the final third out here, and you know, this case, I would suspect that this case is kind of like a statistical outlier, right? This isn't really your standard, and even on the edge of, like, things taking a long time, this one's probably really out there, you know, and so would wonder if you all collect data along those lines.
I guess that'd be a question. I don't, not for me. I can't, Matt, but I don't know. Safe, you know, experts, do you have that ability?
We don't have the ability in our system to track specific releases and to filter claims based off of if there's an end date or not. What we have been doing is trying to gather examples from our claims adjusters as they arise, and then go through them to see what's happening in the claim. This one was selected because it's a pretty clean history, but many of our claims, you know, they evolve as they go to different providers, so it's not always as clear-cut a factual situation, but it does occur with relative frequency.
And I think when we're talking open-ended time loss authorization, yeah, I'm an insurer and I'm going to say it, that in and itself is not really the problem. The problem is there's no guardrails. So in this case, this worker had an open-ended time loss authorization, and the guardrails are normally, before you leave your appointment, you set your next appointment 30 days. So some of the examples we saw was a worker with an open-ended time loss authorization and a follow-up appointment in 30 days and physical therapy in between. And they sought treatment 30 days and they had another appointment in 30 days. Or the physician said, I don't need to see you for 45 days, but here's your appointment to follow up in 45 days. Another example that we saw that I dismissed at first, and Elaine goes, no, that's a good example, was worker moving to Texas. Knew that they needed to establish care in Texas, so before they left, they talked to their attending physician in Oregon and said, I'm going to maintain my attending physician status with you via telemedicine until I establish care in Texas. So we looked at that claim, and the next couple medical appointments were telemedicine, where they were having an appointment with the physician in Oregon, following up what's going on, what do you need to be working on, how are you doing, while they were transitioning care to a physician in Texas. So I guess it's driving down the road without any guardrails, and this is the example where there are no guardrails and time loss is being paid for 16, 18 weeks, and there's not really a way to control that.
Yeah, okay. So I see a couple of hands raised, and I'll start with Margaret. I believe you raised your hand first.
Thank you. Elaine, I appreciate the work that you've put into this, and I also tend to agree with Matt that, I'm worried that this is an outlier, especially when I compare this to what I heard at the last meeting when Jennifer Flood said that her office most frequent call that her office gets is workers not being able to get medical care authorized. So I guess my question is to you, what can you provide, or how do you have data, or is there a way to get this data to demonstrate that this is a widespread problem and not just like an occasional bump and outliers, as Matt called them?
Yeah, I think it goes to what I said earlier in terms of the state's own internal data tracking system, that we can't filter claims, so we have to request this from our claims adjusters and then have them present us with claims where this is occurring. Access to providers is maybe a sister issue of this too, and could be part of the discussion. That access piece is certainly important, and we want to ensure that workers are appropriately able to access care and get care in a timely manner, and perhaps that would be part of a broader solution. What we're seeking is to open the door to this discussion and see what the deeper issues are, and those could be two that really need to go hand in hand.
It's a good part. It's continuation of care is the problem. So part of it. Margaret, you still have your hand raised. Were you done with your question, and I can move on to the next one? Okay. All right. I'll move on to Tammy.
Thank you.
Yeah, you bet. Tammy, you're next.
Okay, thank you. Tammy Ballard here. I'm trucking. I'm a common truck company hat. I can tell you that for us, it's not an outlier. It's happening time and time again, especially with those out of state. Steve Now was talking about, I did get frustrated when our injured workers can't get in to see a specialist for 6 weeks or 8 weeks, or even start physical therapy for 3 weeks. That's a completely different problem, and this other open-ended time off is another problem. I do everything I can to write down all of the information and back it to the doctors to try to get our injured workers in quicker. If there's office closures or everybody's finally doing medical care now, that's a problem. I have one worker who needs to see a specialist and ask me to do something. So that item is not covered in these examples or the problem that Elaine and Dan are bringing up that I see time and time again as well. So I can provide specific examples of injured workers that I have currently just applied.
Thank you, Tammy.
That's just my comment.
Yeah, thank you, Tammy, from your perspective as a claims person. I think that's nice to hear. And I see Scott has his hand raised as well.
Hi, Scott Strickland. I think this is obviously any time that a worker is not receiving care, there's a problem there, especially care that they need in a timely manner. So I'd be interested to see. I think Matt has brought up some amazing points about medical care and access, both in rural areas and during COVID times and all of that. I think Tammy touched on a lot of that too. I think that was great. I think this with all the barriers that we're sort of talking about, it'd be interesting to find out if we have any more data to kind of push out this issue more generally. Maybe I would want to know, are there language barriers, are there housing barriers? I know when Jennifer Flood talked, she talked about unhoused folks and the difficulties they have receiving communications and information. What else is coming to play in a situation like this? And then what other situations and scenarios are there that can be addressed as well, and what's the best way to do I think access to care, like you said, Patrick, is huge, and with the modernization and other things that we're dealing with, talking more about that, getting more information is really helpful.
Yeah, definitely great comments. Matt, got another follow-up.
I guess I do have a question of, or more just a clarification of where we're saying that access to care is not related. I guess we're just saying that it's just the time loss issue of physicians, having that open-ended. Not as you're hearing what Tammy and the folks are saying is you're separating that out from access to care. So the attempt is, or a little confused on how those are not intertwined. Tammy, you had mentioned, right, like you have a lot of these cases and then had some anecdotes about how long it takes to get in. Like I said yesterday, I'm hearing about really important critical cases for people that we were canceling because we're already scheduled, right? We're saying, sorry, not today. And so I'm trying to think of the workers who's navigating that. And I'm having a hard time keeping them apart. I'm happy to maybe gain a little more understanding on how maybe they're a little bit more separate.
Yeah. All right, Tammy, I see that you're going to have another follow-up as well.
I raised my hand. I raised my hand. I didn't know if you wanted me to reply or Elaine to that. Just for me personally, I have those separated out because there's a difference between an individual saying, well, my first appointment with physical therapist isn't for 4 weeks or 3 weeks, or a specialist appointment isn't until September and nothing else. Okay, I understand. A lot of times we'll have a case manager. To me, that's problem that we were doctors or nurses and you were, physicians to treat. To me, that's a different problem from my perspective than the other problem where a worker decides to be nice. Oh yeah, I'm going to go in. Oh yeah, I'm going to schedule something. Oh no, I couldn't find a doctor. Oh no, I haven't made any appointment. Something came up, but I plan to. I promise. I'm getting strength from the law. Not workers, I just seem to want to have treatment, and I like it when workers want treatment, and I help them get that. So just told people before, why don't you, if you're moved into a new area, why don't you go to emergency room or urgent care or something like that to get a referral for a doctor in your area if nobody else will treat you, if you're not able to get it treatment. I mean, we give them all kinds of options to do, and then they still don't follow through. I mean, that's the problem one, and that is something that I deal with often. So that's just my reply to you. Right.
Thank you, Tammy. And our safe presentation team expanded by one to
Us too.
David Berenberg. And he has comments. If Elaine, who's leading the presentation.
Oh, it is your meeting.
Okay.
Yeah.
All right.
So I just wanted to start with just a little context first from how this issue has come before the group, before MLAC. As you'll remember back to the legislative session and the legislative session, there was 4138, which was the time loss bill that was brought forward by the trial attorneys. And MLAC was involved. We, being safe in some of the defense side attorneys and the business community, negotiated on 4138 to a bill that MLAC could support and had very broad support in the legislature. One of the elements of that was that, and MLAC had talked about as part of this deal, was that we would come back and revisit this issue that was important to the defense side over the interim. And that was also what was presented to the legislature, that this issue would be taken up and discussed and worked on over the interim. So, our ask, and this discussion is a wonderful discussion, that this is a complex issue with a lot of different moving parts and components. And that was really the reason why it wasn't addressed during the short session, because we need time to put all of these issues out on the table to then try to solve the problem. The business side had come in with a proposal saying, we want to have 30 days as a limit on time loss. And we came out of the process after working with the trial attorney saying, let's look at the issue of connection to care, and it may have many facets, including working with the medical profession, education, and might have some other guardrails that we want to put on it. But start with, here is an issue we need to look at, and I think that's what we heard today, that, from Member Calzia, gee, access to care is an issue, how does that play with this? So that, I think, would be sort of our request, is to have a work group with the parties involved to try to address some of these issues, put whatever information we can about the situation on the table, and then try to see if we can work to some solutions.
So I hear there's a problem, but there's disagreement about how we define it, maybe.
But does it need to be defined? I mean, it's access to care, it's continuation of care. The problem, I see everyone thinking there's a problem in that.
Yeah. Is there agreement that those two items could be put together and defined as the problem? Continuation of care just by not having access, there's no doctor to make an appointment with, or with those that just don't make an appointment for reasons unknown. And putting that together as continuation of care. Does that seem okay, or would we need more data in order to say that that's a problem? Scott?
Yeah, I mean, I think, Dave, or Scott Strickland, sorry minutes people. I think Dave brought up a good point. This is something that we've talked about addressing. I wouldn't have a problem with addressing this kind of generally in a subcommittee about access to care and sort of teasing these issues out and looking at some more data and trying to address this or having a discussion about doing something like that. I think obviously we are all in agreement that there's an access to care issue and that we have some really good ideas and a lot of information already on how to start addressing this, or how to continue addressing this, and could move forward with that. I don't know if that helps, or does that kind of answer the question you asked?
I feel like you did say that you feel like there's a problem, and it's access to care, and that you support moving forward with studying it. And I heard Sarah say the same.
Agreed.
And I don't know, so that's two, that's one on each side, and I agree with it as well. Does anybody disagree with that? That it's okay? I see a thumbs up. Matt, did you give a thumbs up? I see thumbs up. Okay.
Yeah, this is Matt, and I give a thumbs up, yeah.
Okay, good. All right. So since we've defined a problem, there was a way to address it. Excuse me? So since we have a problem, we need to address how we would proceed, and a subcommittee was proposed. But I heard some commentary about, is subcommittee the right thing? I think me personally, new to MLAC, and I know Sarah has started at the same time as me, what are the options and what are the pros and cons of the different ways we meet as a group or put together a team of people to meet and study this problem? And I don't know if, Teresa, you could support us and tell us, based on your years of experience, of how these have been put together.
I think really what it boils down to is time, and how much time, and also the priorities of the committee. I mean, you do not have any formal requests from legislators or the governor in looking at topics. So it's, you have a clean slate. However, there are items on your work plan as well to consider. And so part of it is prioritizing, what does the committee want to work on between now, in the next few months? Because probably starting in late summer, early fall, there will be starting to get requests from stakeholder groups on their legislation and trying to have the conversations teed up in advance of the 2023 session. With that, that may happen or may not happen, but it's just, it really boils down to time and what the committee priorities are on looking into topics.
Do we have admin support?
That's a great question. I think it also depends on, it's that also too, Sarah, I didn't provide a complete answer. It's also how much time you as a committee have individually and collectively as well on this. There's that to consider too. But we will make it work. We'd have to have internal conversations, and we'll work with the co-chairs, but.
Okay, I see my co-chair Scott Strickland with his hand raised.
Yeah, Scott Strickland. So I mean, it sounds to me maybe September would be a good time to have a subcommittee so that we're sure that we have time for, for Safe OLA and the others to kind of do a little bit of initial research and kind of put something together, or we can generate some questions, reflect on it. And then that way, since we have that time carved out, and we can make sure that it's not getting lost in the midst of everything else that kind of bubbles up around that time. Just an idea, I know there's some folks may have summer vacations and such before then, so scheduling would be difficult. Would folks be open to that as a possible suggestion?
I have just a procedure. Why do we need to wait till September to get started?
Well, it just seems to me like that might be a good time because it would provide a couple months for the parties to get more information, get some answers to the data questions that we had, and then also make sure that we're carving out time that we have voted solely for this issue of access to care.
Yeah. Thank you.
Tammy, did you have some follow-up as well?
Well, I was just gonna say, I like this idea to give parties a couple of months to prepare, because my guess is that Elaine and Dan have a solution, and, now's not really the time to discuss it or present it, but my guess is they've got a solution, and so maybe they want to gather more information for it to present that. I don't know, I'm just guessing.
Are we allowed to ask them? Do you all have a solution? That's what I heard Tammy say, that you don't need to wait till September, you have a solution. Is that true?
We had proposed language to the trial lawyers throughout the discussions prior to and during House Bill 4138. So that would address open-ended work releases and put us in set some guardrails to require some contact between workers and their medical providers on a consistent basis. I'm not saying that contact would have to be a full medical appointment. It could be a phone call or a telemedicine visit too, just to ensure consistency there. So we do have that draft language that's already been shared with OLA months ago, and we've had lots of discussion. So this piece and the discussions we have shouldn't be a surprise to the trial lawyers. I would expect that they would be ready to discuss this issue because it's already been discussed, and it was already agreed that we would continue the discussion. And our preference would be to begin those discussions sooner rather than later.
If we have an open slate now.
Yeah. Were the trial lawyers invited to present as well? I know the original agenda said presenters to be announced. I don't know if that was an open-ended invitation to those or other stakeholders.
The presenters I have were formal presenters, but there are representatives both here in the room and in Zoom that represent OTLA. So I don't know if they want to speak to this.
I see one with his hand raised.
Yes, I say Keith. Yes.
Yeah.
You're on mute.
Though, Keith.
Hi. Keith Semple with the Oregon Trial Lawyers Association. We did agree to continue this discussion. We've already expressed some of our concerns about some of the proposed solutions and how those would operate. But we've committed to continue the discussion, and hopefully we'll identify some tailored solutions to some of the issues that have been raised. I guess for my part, I would agree, if the worker described as my client, that would be a problem for me in terms of how things were going with the claim. That's certainly not the strategy that I would espouse for workers seeking care and getting treatment and getting work restrictions. But the idea of a 30-day hard deadline on any and all work restrictions is a real concern for us. That really puts the worker in the position of policing their own doctor and all the conflicts that might arise over that when doctors are out on vacation, et cetera. But all of that said, we've agreed to continue looking at the challenges that are faced by workers and by the insurers in these claims, and we're prepared to continue those discussions. So yeah, we don't have any objection to having this go to subcommittee whenever that might get started.
So subcommittee, How many MLAC members typically?
There's no quorum requirements for the subcommittee. The bylaws do mention that there would be representation from both caucuses, but actually, since I have a copy of it, I don't want to misspeak. So the procedure for the subcommittee is that the co-chairs appoint the subcommittee. Then there's specific things such as timelines in which the subcommittee completes their work, reports back to the full committee. In creating the subcommittee, the co-chairs must designate an equal number of members, and then the charge and the deadline. But there is no quorum requirement. So, like for example, if there's an imbalance, the subcommittee can continue to meet. Yes.
Okay. Thank you for defining what a subcommittee composition is. And so, an equal number, does that just among caucus members or stakeholders as well?
That would be amongst caucus members.
Caucus.
And that's actually Andrew brought up a good point. Yes, and actually the co-chairs can do the appoint stakeholders to the subcommittee, but there is no definition of you can appoint 2 or 10 or 50.
And they don't have to be equal.
They do not have to be equal. No.
Load both sides.
Yep.
If we were under,
But something tells me there would have to be sign off from the co-chairs, so so there is that to consider as well.
Yeah. All right, does that sound agreeable to everyone? So waiting till September to have a subcommittee meeting, which means that the composition would be made soon, before September, and that those people would meet and present their results in September. Is that what I'm hearing?
September seems to me far out to form a subcommittee.
What we can do is, Sarah, perhaps I'm bringing to the co-chairs, and we can talk about this before issuing the July or the August agendas. Maybe perhaps have a formal item for an update from stakeholders on this conversation.
I'd love to see a subcommittee form by the next meeting.
For July, okay.
I would.
Just want to point out that the subcommittees have been around for a while, but when we kind of redid the bylaws and refocused on things, kind of reimagined how they were going to be. A lot of the feedback that we got in putting this together was that there wasn't as much kind of structure and I won't say formality necessarily, but like formality around forming a subcommittee in terms of deadlines, specific deliverables, members, etc. So it's new-ish, not a new idea, but the structure around it is a little bit newer. Mm-hmm. This will be the first time MLAC's really going through with it. So it'd be important for the co-chairs to really think, and we, the department, can help in membership and a mandate and timelines and things like that, just to help it operate.
And then there also is the deadline it is formal, but if there is legislation that needs to be introduced, there are deadlines for that as well. But when in an appropriate time, we can talk about that. Those are set by the legislature.
So Scott, as co-chair, do you have any strong feelings to put on the public record? Do you want to wait to kind of talk about it when we have our regular meetings with Teresa to set agendas and kind of defer it till then?
Scott Strickland. I'd say it'd be great to have some discussions about how this works and what the timelines are, so that we aren't blowing any timelines or putting any undue pressure on folks to miss, legislative session, next session, and all of that. Maybe if we could touch base about this and then address timelines then and figure out how to best do this so it works for everyone.
That sounds good. You became louder in this room.
And then there was the howl.
And then there was a feedback. So, but I heard everything that you said. It sounded like good feedback. Good. The feedback wasn't good, but what you said was good. And I'm okay with waiting in the reporting back in the July meeting.
That's great.
About what our findings are. But I'm hearing that it's informal. So it's something, and we'll be breaking new ground about the new subcommittee. All right, well, that sounds good. Any other discussion, any other presentation that you have to bring before us? Any other comments, questions from the caucus?
We need to pause.
All right, thank you, Administrator Van Winkle. I am reconvening the meeting, although due to sound loss, I didn't take an adjournment. But thank you, everyone has stayed on the line. I have 40 participants and nobody left in here either. So we will continue our discussion, which I think was just wrapping up. Are there any other questions, comments, or concerns about worker continuation of care or any of the items we talked about? Okay, seeing none, we'll move on to the next item, and I would like to thank the people for their presentation. And next item on the agenda is vocational benefits and immigration status. And we do have new presenters that are coming in. We have Julene Quinn and Aaron Klingerman. I see Elaine is staying put, so you're part of the
I'm part
team.
of the group this time as well.
Okay, all right. Starring role today.
I suppose so.
Yeah.
So we're bringing a concept to MLAC to see if there is interest in pursuing an issue surrounding vocational benefits. Currently, the way the law is structured, workers who are at a certain point in their claim process, of their claim being processed, may be eligible for vocational services. And that can include things like on-the-job training, skills building, resume work, assistance, educational services, computer skills, a wide variety of benefits. And one of the requirements currently for a worker's eligibility for those services is that they be able to prove their ability to work legally in the United States at the time of the determination. And Safe approached some of our partners, Ms. Quinn and Mr. Klingerman, earlier this year to talk about a potential solution for those workers who are unable to prove their legal ability to work at the time vocational entitlement is being determined. And one of the situations where we see this come up is workers who have an on-job injury. They have the ability to work legally at the time for the work visa, and then are injured on the job. Their work visa expires, and while they're moving through that claims process, they're found ineligible for those vocational services because they can't meet that proven ability to work legally in the United States. And so, in discussing this issue with our partners, what we thought a potential solution would be to carve out some of those benefits and make them available to workers at the time of vocational determination, short of providing direct job placement skills or job placement training, where we're helping them find a job even though that individual may not be able to show their ability to work legally. There are some constitutional issues with the current rule as it's written. It's an administrative rule where that requirement lies right now. And so Julie is here to talk about that if the members have questions. And Aaron is here to talk about the immigration piece in further detail if you have questions. We're just seeking to start this discussion and dialogue with the committee members. We know that it's something that would be of interest to the Workers' Compensation Division and the Employment Services team. They're the subgroup that administer the vocational rules, and their input would be very valuable and necessary to make any sort of determination in this arena, whether our proposed solution would be something that could move forward or not. And there has been some initial outreach there, along with the Ombudsman's office, or Ombuds office, I should say, with Jen Flood, to get her engagement here.
The proposal is also a little broader than vocational services, but let me back up a little bit. Holly Odell and I and Elaine and I worked years ago together at SAFE, and Holly and I, our daughters go to the same athletic center, and one day we were talking, and I was talking to her about, the next constitutional challenges I had, one of which is to challenge the fact that foreign workers, their time loss can be cut off, and they're not given vocational services simply because they're not legal to work at the time, and yet there are so many, in talking with Aaron Klingerman, there are so many different circumstances. A worker may be legal, or may think they're legal to work, and then suddenly are not, and that constitutionally, they're injured just like, the legal worker. They're both injured. They are both given up their constitutional rights to sue the employer. Those employers both have an exclusive remedy so they're protected from a lawsuit, and yet you're giving them two different benefits. And to me, that's unconstitutional. So Holly and I were talking about this, and then she came and discussed with me, well, Julie, let's change the law, because, you can put your effort in changing the law or changing the law in the courts, either way. So I, in talking with Holly, said, well, look, if SAFE is with this, and this is a joint proposal, I'm willing to go forward. Because you've seen me at MLAC meetings, my expertise is at the court. My expertise is not as a lobbyist. That's Art Towers. That's Dave. That's not me. I do better in the courts. But Holly convinced me that it's worth taking this forward. She did her research with her stakeholders, and I discussed it, on my side. I did want to say I'm not here as an OTLA member today. This is not an OTLA project. It's Holly and Julene decided to do this, take it forward, and I dragged Aaron along with me. But, we're in talking with Elaine, who has taken over this project from Holly. She said she was interested in pursuing it, see what would happen. And if it's a joint project forward, I'm all for it, because I've both seen the difficulties of it and the unfairness of it, because workers who, they're hurt just the same, and they're starving just the same. And the time loss benefits is one of the cornerstones of that quid pro quo to give up the right to sue in civil court. The quid pro quo is quick and immediate benefits in terms of time loss medical and then ultimately permanent disability without having all the other higher benefit damages you can get in court. And so to take away one of the cornerstones of the few things you get in exchange, I just felt I could make hay in the courts with that. So that's sort of the basis of trying to take this forward. It sort of fits with the policy issue in workers' comp. The stream of commerce that causes the injury is what should pay for that injury. And when you take things out of the stream of commerce, foreign workers, suddenly taxpayers are paying that as opposed to the stream of commerce that caused it. And anyway, so I put it all together. I think it's a very worthy project. This is a good time because workers are at a premium right now. And so anyway, that's where this all came from. That's the impetus for it. And so I've reached out to the Ombuds office, Jennifer. I've reached out to try and get a representative from WCD, and then we thought we would talk with you and lay this out, and then start gathering stakeholders and people to review it to see if it can go forward as a legislative concept for this coming legislative session. So there we are.
Did you have
I don't really have a specific presentation, but I will sort of explain the archetype situation problem that this presents. If you have a farm worker who comes to the United States on an H-2B visa to pick apples or something in the valley, and they get hurt, their right to be in the United States and work terminates when the work ends. In other words, when they are no longer working. And so the employer has to pay for their trip home within 60 days of that termination. Well, if you break your leg severe enough, it takes longer than 60 days to get healed. There are other visa classifications that worker could slide into or move into to stay in the United States, and there may be, whenever he is well, he may have found a visa classification, that permits him to also work in the United States. And so if that worker gets hurt and 60 days later he's on a bus going back home, that's fundamentally unfair when he should be given the same rights as everybody else. And when Julene and I started talking about this, the immigration law is probably a little bit even more complicated than workers' comp. And the legality and the right to work are even more fluid than most people think, because most people think green card, I'm here, I'm allowed to work, but there's a whole other side to that. There's a whole entire alphabet of visas depending on what the reason that you're here for to come in the United States. And some of those categories are work visas. Some of those categories have limited rights to be here, and you either can work or not work, or depending on your individual circumstances, have a right to ask for a work permit.
Thanks for defining it, the problem. Are there any questions for our presenters?
Just a clarification, ag workers H2A, correct?
I think
H2B is,
I might have those mixed
Okay,
up. My immigration practice was primarily family law as opposed to employment, but it was just danger enough. I might have that mixed up.
I believe it's H2A, and I am in support
as opposed
of
to
moving forward.
H2B. You can check really quick if it matters, but I don't think that's significant for
It is not.
today's discussion.
I'm in support, thank you.
You're in support of hearing more and
I'm going for
with
you.
this comment. Right. I hear in person, one person in support of going forward. Is there anybody that disagrees as they sit at home or wherever they're at?
You're right. H2B is non-agricultural temporary workers.
Thank you, just a
Yeah.
quick clarification.
Any other? I see Scott Strickland has his hand raised.
Strickland, hopefully I won't break the meeting this time. Yeah, I think this is definitely an issue, and I just wanted to thank everyone on the panel for bringing it forward and being knowledgeable about it and wanting to address it.
I think I'm hearing consensus, maybe, Teresa, since we don't set legislation, what is our role as MLAC in this, bringing it forward?
I mean, my understanding, and please correct me, presenters, if I'm incorrect, this is just kind of this is on the radar for the committee to look at. I know that we've had like a very, very brief discussion, basically Sally and I talking about this. It sounds like there will be, conversations between the presenters and WCD on this and in shaping potential legislation. So probably, I'm guessing the next steps will likely be, but of course there's no guarantees, is that once language has been formulated, there could be an update on this in front of the committee. But nothing formal that needs to be organized by the committee at this time.
Right, so the project includes both a rule change and a statutory change that go in different directions. And so at some future time, as you know, the legislature likes to have MLACs review and stamp of approval on legislative language. So we would come back to get that, and then there would be a rule change issue through WCT, which I believe comes through MLAC for advisory. Not that good at that, but anyway, certainly we would keep you updated on it. So, with an eye towards the legislative sessions.
Just making sure we know in advance
Right.
of that quick review we're going to be asked to do in the sessions. Okay.
Right. If we hit a buzzsaw today, we would think twice about where we're headed. I guess to be really direct, we just wanted to see, okay, let you guys know and then get a sense of room, and then if you had questions, concerns, or other stakeholders you felt were important, we would gather all that information so that as we went forward, it would be a complete packaging review for you to assess and input.
Thank you. I see no buzzsaw. So I
Thank
think
you.
you're free to proceed. Thank you for bringing the issue forward in your
All right.
presentation today.
Thank you. Thank you.
All right. Our next item on the agenda is a follow-up on managed care organizations, which was the bulk of our meeting last time. We heard a lot of presentations on it. It is an item on our work plan to look at managed care organizations. And so I think there is committee discussion about what we heard last time. And perhaps topic of discussion is whether or not our work plan is complete or needs to be adjusted.
And before we start conversation, Mr. Chair, we do have copies of the work plan draft here in 260, and I have just uploaded a copy in chat for members and stakeholders to look at. So
Thank you.
everybody's on the same page.
Thank you very much for doing that.
Okay.
I have a printout in front of me, but yeah,
But I
feel
have a
free to
printout.
refer to that. And I would ask for members of the caucus to speak up and give their feelings about the managed care organization presentations we heard, whether they addressed what is on our work plan, and whatever they would like to speak about. Is there any hands raised or commentary on it?
I'll go if no one else
Okay,
wants
Sarah,
to.
go ahead.
I found it extremely informative to learn more about the system as it is working or instituted, and I feel it was working. And I'm not sure it remains necessary to keep it on our work plan unless others, feel that it's broken in some way.
So thank you very much, Sarah, for that commentary. Does anyone feel like it still needs to remain on the work plan? Scott?
Yeah, Scott Strickland. Surprised that I'm still interested in addressing this, I think, a little more. I think I had some follow-up questions on specifically some of the issues relating to the communications that were given to workers and the way that process goes along. I know that I had some interest in how the come along provisions work, potentially hearing from maybe some providers who've been through that process or from workers who have been through that process as well, to hear from kind of those sides. And I think as well, I know some of the communications issues, I think I brought up last time of how the MCOs seem to be making the medical decisions, and when those are communicated to the workers, that there might be some confusion about whether something is medically approved or required versus the actual approval for the payment of that, and how that process works, if there's any opportunity to streamline that as well. And I think a couple other issues. I don't know if this would be good for a meeting, maybe a couple meetings from now, and we can pull some workers who've been through the process, and maybe some healthcare providers or others to talk about it and get some of the follow-up information. I think there were a couple questions I had the first time that the MCOs presented that we haven't gotten yet.
Okay, thank you, Scott, for that. Some idea. So who would organize?
Just
Go ahead.
real quick too, I don't want to just dominate. I know we have a great work plan, a lot of stuff. I don't want to just dominate on the MCO issue. Do you recognize that?
Thank you for that. Any other comments or questions? Right, I don't hear.
Well, I have a quick, Scott, on the MCO issue. I recall you asking for some follow-up. Did you receive that, or did that? Okay.
Yeah, this is Scott. Not yet, but I did want to follow up with the folks on those questions again, because I know that things have been busy.
Okay, well, that's fair. That's something that's open. And then you did ask for some presentations of workers that went through the process and providers. I remember one provider that spoke when we did it. I think there was one doctor, but maybe more. Who would organize that? I don't know of any. I know you went through an MCO, Scott, and you spoke already. But do we want to ask Teresa, hardworking Teresa, to help us find some people to present on that, or maybe some of the stakeholders?
I think, yeah, maybe doing some stakeholder outreach. I know that labor folks would be happy to pull some workers and stuff and get some commentary. And about the system just from some different perspectives, because I think we had some really great information and presentations from the MCOs, and got a lot of information about what they do and how they do it and the value that they can bring in those situations. But I know that feels like kind of, aside from me with my anecdotal experiences, we haven't really heard as much of a broad perspective on the issue to get a couple other sides to it.
Yeah, that's fair enough. I'm not opposed to any of that, other than I wouldn't be able to organize it myself. But it sounds like we can work together as we move forward and put that on the agenda in the future. As it relates to the work plan, though, I'm looking at that right now, and I see at least one item, Ann Klein volunteering to educate and provide data. I think that's done. I think. It was very good. I could hear it again and again.
I have no problem talking. I'm sure I can do more, but I'm hoping that was sufficient.
I think we could mark that as complete. I don't know if anybody would dispute that. And I don't know, methods of communication you mentioned, that I think that's what you wanted to follow up on. So that's still open. Delay in care, rights discussion, are those still open as well, Scott? I don't know. Is that kind of what you're hoping to explore more about?
Yeah, this is Scott. I think the idea of the delay in care and the process that folks go through, partially as it relates to come-alongs or enrollment process, but partially just, like I said, with the, sort of a two-step approval, approving something as medically necessary or important, but then also getting the insurer or whomever to sign off on that as well to pay for it. And then the way that all of that's communicated to the worker, in terms of, is there any questions of, through a DEI lens of questions of how is it transmitted, how is the information transmitted, is it in a language they can understand, and written in a way that they can understand and access. So sort of any kind of perspective or streamlining that we can get on that. And then I know that kind of folds in too, that we've talked about like a workers' bill of rights or something like that, and putting that together, discussing that, or a listing of that could maybe be provided at onboarding or the beginning of a claim process or something like that. And that might kind of intersect that, when you have that enrollment, that you also get sort of your rights in this context, sort of a thing. I know that a lot of that's already done, but if we could just, see those things and take a look at it and hear a couple stories, I think that might help illuminate if there's any issues there and how we can do better.
Okay. Anything else, or anybody that is opposed to any of the things that Scott mentioned? All right, it sounds like it's solid, and I don't know if we will edit the work plan to reflect any of these changes?
Yes, actually, Mr. Kocher, you bring up a good point. I think staff, we are overdue in doing a reformatting of this, and also partially because because of today's update on the MCO piece, but also kind of like doing a kind of a, I'm trying to think of the right word here. Basically, using this topic and then also the topics we talked about earlier, and having those slated for potential agendas between now and next year. Just basically kind of fleshing out draft agendas as well. Because that will also help in regards to estimating time for the committee members and also time for staff, and in identifying any additional outside items that we may need to do, any missing pieces to complete the work plan piece.
I took this agenda item that we're on right now to just be a general discussion of the work plan topics. And so if anyone, it has been posted in the chat, and I know members of MLAC have all received this at one time. Does anybody have any comments on things that could be, taken off? Any new items to be proposed to put on there?
Besides the two for today, those will be
Besides
added on.
the two for today, we have two that we added on today. And see, Tammy went on camera. Was that just to say hi, or you don't have anything else? Okay.
I have a couple.
Okay, sure.
Just procedurally with onboarding, and Teresa and I talked a little bit offline about this. With Workday, it was a fairly egregious experience, and I don't know in general with Workday moving towards that platform I can imagine transitions are challenging, and I can give grace on that. But we do have new members coming in September, and I would like to see a more streamlined and easier process for them going forward on the onboarding. And then I'll get us all up to snuff on where we need to be as well. And then just to dovetail off of that, with this lofty work plan in place, do we have enough staff support? Should there be more? I don't know. I mean, everyone is extremely busy, and how could we address that?
And that staff at the DCBS, we're talking about in particular. Is that okay? Can we add that on our work plan?
I think that, Mr. Co-Chair and Sarah, I think that's probably what we can do too, is as we format the work plans, maybe start that conversation. I think, I'd like to start the conversation, not just with the co-chairs, but I think also with both caucuses as well, and have them the open dialogue as well. I also want to point out too, because I'm actually point out an item that Scott has mentioned. I don't believe in a full committee meeting, but one of the items under the educational sessions is on DEI. And so there has been interest in having the committee receive information, training, kind of toolkit on how to look at workers' compensation policy with the DEI lens. And so I have been working on potential items. And so that may likely be a new item for the onboarding piece. This will be round 2. So as with the first go-round of the onboarding, current members can participate as well. I also want to point out too, actually, Sarah, you triggered my thoughts as well on, because your onboarding was the first time we did something this formalized. It's also getting feedback from the 6 newish members on what worked, what didn't, and how we can improve our onboarding to make it a great experience for new members coming on, particularly right before session in the reviews.
Did you want that at this time, or would you like?
No, we can do that down the road. I just want to put that marker there since we are talking about the work plan and onboarding.
Okay, well, thank you. I'm happy to do that. So, I also agree with the training classes. I know we were eager to. We were. Our responsibility is to take 3 classes, and I don't know what the third one is yet. Still, and so it'd be nice to.
Yes, I will provide an update to the members on that. So for those of the audience, there are required trainings for new members when they first begin their terms. And this is not just for MLAC, it's any board or commission that is under governor's appointment and Senate confirmation. And there's also ongoing classes, trainings for members to take annually. And so I think, Patrick, what happened to you when you sent me an email, the public records training will be for continuing on. So I have to go through everything. I have the DCBS Workday Guru we're helping me tremendously in trying to get some solution on this. And there might be some workarounds too for Sarah. I believe it impacts Matt. I know Marcy, I think Marcy and Margaret does not impact you because you were already in the system with Workday. For various reasons, but we will work this out, and hopefully we'll get all of these issues straightened out before we start the onboarding of our new members, which should be, depending on executive appointments, at the end of September.
Well, thank you. Any other comments on the work plan itself? I'm hearing none, so I think we'll work on it. The co-chairs and you, Teresa, will work on it and bring something back.
Yes,
to a future meeting.
And I'll reach out to individual members too, so it's not just because these are decisions that I believe are for the entire committee, not just leadership.
Okay. Are there any other topics to bring before this group today?
The only other item really is kind of not really follow-up, but if you recall for our first hybrid meeting, I mentioned kind of some ground rules, in which I did put together a kind of a document on this, and so I think for the next meeting, what we can do is possibly put that into an updated bylaws and handbook and include those ground rules. And it's nothing earth-shattering. It's just how DCBS staff will do to make sure that we have equalized access and participation for those that are here physically in the meeting room, which is the official location of the meeting, and those that are participating via Zoom.
Okay. All right. Well, thank you for that. Anything else from the members of the caucus? All right, well, seeing none, I would adjourn the meeting a couple of minutes early. I'll give you 10 extra minutes of your day. Thank you very much for your participation, and we will see you next month.